indulgence of my lord to item 19 and 20, my lord. This IA has been filed mistakenly, and in the main read petition item 20, my lord, there are subsequent development after filing this. So unless if I don't integrate those subsequent developments in this read petitions, I cannot improve my read petitions, and neither I can get any relief. So therefore, my lord, kindly grant me a leave to withdraw with a liberty to file fresh in a composite manner, my lord.
Item number 20,
19 and 20, my lord.
19 and 20. Mr. T.T. Tara, learned counsel for the petitioner. In item number 20, applicant in item number 19 submits that he may be permitted to withdraw this IA and WPC with a liberty to approach this court again by filing appropriate petition. Where is accordingly allowed. IA number so and so, WPC number so and so is not disposed of withdrawal. However, liberty will remain with the applicant and the petitioner to approach this court again by filing appropriate petition.
Grateful, my lord.
My lord, I may be allowed to mention item number 8 on behalf of Mr. R.L. Thongan. My lord, this matter may be listed after 2 weeks.
After 2 weeks.
Yes, I'm for the respondent number 4 and 4, 5, and 6, and I have taken consent from the petitioner.
Okay. As agreed by learned advocates of both the parties, raises and lays the matter after 2 weeks.
2 weeks.
My lord, entry may be
So,
considered.
excuse me, your lordship. Excuse me, your lordship. I'm appearing on behalf of the petitioner.
After?
My presence may be recorded, your lordship. I'm for the petitioner.
Okay.
I'm for the petitioner, your lordship.
Heard, Mr. C.W. Mantao.
Yes.
Okay.
Yes, your
Learned
lordship.
counsel for the petitioner. And also heard Mr.
T. Omo on behalf of Mr. R.L. Thongan.
Learned counsel appearing on behalf of Mr. R.L. Thongan. Learned counsel for the respondent number. Respondent number
4, 5, and 6.
4, 5, and 6. As read for by Mr. So learned counsel appearing on behalf of Mr. R.L. Thongan. Lays the matter after 2 weeks. After 2 weeks. Interim order pass earlier shall continue.
Obliged, your lordship.
May I, lordship? Item number 4, lordship.
Yes.
Lordship, matter may be listed after 3 weeks, lordship.
Why?
Item number 4, lordship.
Why?
Because lordship, leading counsel is out of station.
Who is
For-
the leading counsel?
Arsenal, lordship.
You said this matter is pending since the year 2020.
Yes, lordship.
So how long?
4 fixed cases.
Pardon?
4 fixed cases. He urgently take up for Changlang, lordship.
Mr. Your good name?
N person, lordship.
Learned counsel appearing on behalf of Mr. R. Sonar, learned counsel for the petition. Appellant. You inform the other side?
Lordship.
You inform the other side?
Yes, lordship.
With consent from the other side, press for listing the matter after?
Lordship.
After?
After 3 weeks, lordship.
After 3 weeks. Bear allowed.
Lordship, I would like to mention item number 7, your lordship. Here I have to file affidavit, your lordship. 3 weeks may be granted. I have taken the consent, your lordship.
Ms. Arbasar, learned government advocate for the respondent authorities with consent from the other side, press for listing the matter after
3 weeks, your lordship.
3 weeks, so as to enable her to file affidavit in position.
Obliged.
Bear allowed.
My lord, I would like to mention, my lord, item number 5, my lord. I'm appearing for respondent number 5. My lord,
Item number 5.
5, yes, my lord. I'm appearing for respondent number 5, my lord. Today I'm going to file reply, my lord. Matter may be listed after 3 weeks, my lord.
After
3 weeks.
3 weeks.
Yes, ma'am.
Mr. Your good name?
PK Gore.
PK?
Gore.
PK Gore, learned counsel for the respondent number?
5.
Respondent number 5 with consent from the other side, press for listing the matter after 3 weeks.
Yes, ma'am.
After 3 weeks, bear allowed.
Obliged, my lord.
May I, Your Lordship?
Yeah.
Your Lordship, I beg to mention item number 23 on behalf of K. Tama, Your Lordship. This matter may be fixed on 2nd of June.
On behalf of
Ketama,
Ketama. Mr. Your good name?
Jithring.
Learned counsel appearing on behalf of Mr. Ketama, learned counsel for the petitioner. With consent from the other side, you inform
Yes,
the,
Lord, yes, sir.
with consent from the other side. As for listing the matter on 2nd of June.
2nd of June. Your Lordship, there's an interim that may be
Fair allowed, interim order pass order shall continue.
highly over. Your Lordship.
May I please, Your Lordship?
Hmm.
Lordship, in this matter, Lordship, this is pertain to NIT, tender matter, Lordship. What happened, Lordship? The NIT was floated. NIT was floated on 11/4/2025, Lordship. In respect of for procurement and supply of material under MD Narega CD Block Chetam, Upper Subansiri District, Lordship, for the year 2025 and 26, Lordship. What happened, Lordship? After the NIT was floated, Lordship, from the class 2 eligible bidders, Lordship.
Okay, all right.
Lordship.
You tell me, what is the basis that the respondent authorities are influenced to settle the contract in favor of L2 bidder?
Lordship, in that is, Lordship, from the reliable sources, because from the last 1 month, Lordship.
No, can you maintain one writ petition on the basis of reliable information?
No, Lordship. Some authentic documents has to be there, Lordship. That is true.
Hmm.
Now at this stage, Lordship, I'm only praying for the Lordship, since the authority are bound to bring the tender process into a logical conclusion, Lordship. Let them at least, Lordship may kindly come, the page 38, Lordship. Page 38, Lordship, this is contain of special tender condition, Lordship. Clause 14 point subclause 2, Lordship. Wherein, Lordship, it has been the joint mayor, Lordship. The joint director shall further scrutiny the tender documents recommended by project director. The LOI will be issued to L1 firm if the tender document recommended by the project director is up to the satisfaction of the acceptance of authority, Lordship. Now, Lordship, since the financial bid has been already offered, Lordship, I became an L1, Lordship. I've been waiting for the respondent authority to act upon as per the special condition given in the Lordship.
Okay, Mr. Pisa,
My lord. My lord, this writ petition actually is misconceived, my lord. The tender, my lord, is still in process, my lord. My lord, let's see, my lord, page 38, my lord. Awarding of work orders, my lord. The process in page number 118 and 119/20 has been done by invoking, my lord, Roman 1, my lord. The district level has done their part, my lord. Now the director level has to do their part under clause 2, my lord. Now it has not been done, my lord. So the tender is still in process, my lord. So, my lord, premature, my lord, this writ petition is
If
premature.
that is the case, Lordship, the bid validity has been prescribed in the NIT, Lordship. That is the 6th June of 2025, Lordship. Today is 29th, Lordship.
My lord,
Now within
6th June is yet to come, my lord.
yet to come from the last 1 month, the exercise which are supposed to be done by the director, Lordship, has not been done, Lordship. Until and unless there is some fishy going on inside the room, Lordship. Why the tender authority is taking so much time to issue the LOI, Lordship?
My lord, may please come to page 13, my lord, of the writ petition, the prayer portion, my lord.
Hmm.
13, yes, my lord. Mandamus shall not be issued, my lord, second paragraph. Mandamus shall not be issued directly in response to issue LOA in favor of the petitioner pursuant to the NIT that is so and so, my lord. My lord, the tender process is still in process, my lord. How can we issue, my lord, LOI to him, my lord? To the petitioner, my lord.
From the record itself, Lordship, technical bid has been completed, Lordship. In technical bid, I have been qualified, Lordship. Financial bid is over, Lord. I become declared L1, Lordship. Now the technical financial bid lordship, it was opened on,
Mr. Pisa,
My lord.
you obtain a verbal instruction that what is this, the process is pending.
My lord, otherwise also, my lord, may I, my lord, otherwise also, my lord. Whether the court can direct the authority to award work to someone, my lord. That is another question, my lord, because the prayer itself says, my lord, they should be given the work. Now the exercise is still, my lord, in process, my lord.
Hmm.
So, my lord, how can we, my lord, how can the court direct the
No, if 6th of June is the last date for settlement of the contract, then
with validity, my lord? Yes, with validity, my lord. Lordship.
Hmm.
As claimed by them, yes, my lord.
it's on the record lord. Name the NIT lordship. Lordship may kindly come to the page number.
page number
Page number lordship 34 lordship, 24.
24.
Serial number 14 lordship. Serial number 14 lordship.
Hmm.
The last date of bid validity is dated 6 June 2025 lordship. Now the once the bid validity is over lordship, without extending it lordship, I become an L1 lordship, my the right of becoming an L1 will be violated lordship. Because from the face of the record, it says I'm not the L3 and came before this honorable court to seek a direction from the department lordship. I become an L1 lordship. Entire process has been done as per the condition given by the NIT lordship. Now what is the what stopping the respondent authority to invoke the 14.2 clause lordship, which has been prescribed in the NIT lordship itself?
So we will list the matter on Monday.
Lordship,
In the meantime, you obtain instruction.
lordship.
Why the matter is getting delayed?
My lord.
Hmm?
Yes.
Because this 6th of June is approaching.
6 June, my lord, today is 30 May. my lord.
30,
6 days we have.
In the 1 month lordship, the 1 month has passed lordship. They have not done anything lordship. In 6 days, let them get an instruction lordship.
Heard Mr. T. Goram, learned counsel for the petitioner, and Mr. D. Lisa, learned standing counsel for the respondent authorities.
All the respondents. my lord.
Oh, all the respondents.
Yes.
In this petition under Article 226 of the Constitution of India, the petitioner has right for issuing direction to the respondent authorities to issue LOA in favor of the petitioner pursuant to the NIT dated 11/4/2025 for, within inverted comma, supply of material under MNREGA 2025-26 in respect of CD block Sitam, Upper Subansiri district, Arunachal Pradesh, within bracket package 3. Package 3. Mr. Goram, learned counsel for the petitioner, submits that pursuant to NIT dated 11/4/2025, the petitioner, being eligible class 2 contractor, has submitted his bid in respect of supply and procurement of material under MNREGA 2025-26 in respect of CD block setup, Upper Subansiri district, Upper Zoo. And the cost of the said estimated cost of the said project is 5 crores 36 lakhs 45,700 only. Thereafter, on 1/5/2025, financial bid was opened, and upon evaluation of the financial bid, the petitioner was found to be L1 bidder. Mr. Goram further submits that being the L1 bidder, the petitioner was waiting that the letter of award would be issued by the authorities And upon signing of the contract agreement, the work order will be issued in his favor. But till today, the same has not yet been issued, and the bid validity will expire on 6/6/2025. And if the authorities fails to issue the LOA within the aforesaid period, then the petitioner right would be violated. For control, Mr. Lisa, learned counsel for the respondent authorities, submits that the process is still going on.
Yes, ma'am.
Process is still going on. And uh, and the present rate petition is premature. Is premature. But taking note of the submission of learned counsel for both the parties and also considering the facts and circumstances on the record, it is provided that Mr. Pisa shall obtain instruction regarding the present status of the said process and apprise this court on Monday.
My lord.
Places are the matter on Monday.
Deeply affections.
May I please your lordship? Lordship, this is a matter challenging challenging the order issued by Deputy Commissioner UPI on dated 16/5/2025, whereby in that particular order, the DC UPI has suspended the operation of all the weekly markets within the administrative jurisdiction of Papumpare District Rural. And therewith also they have DC UPI has cancelled the trading license and permit issued to all the weekly markets issued to any individual association or whatever extra. So being affected, here the petitioners are the owners of weekly markets possessing a valid trading license, and they are adversely affected by this order. Since the issuance of this order, the weekly market has been stopped, and they are solely dependent on the weekly market for their livelihood sustainability. And now against the order of Deputy Commissioner UPI, the petitioner have submitted a representation to the DC UPI to revoke the said order and reconsider the matter. Your Honor, your lordship may first look into Annexure 1. Your lordship will find in page 21, your lordship will find the order issued by DC UPI. With your permission, may I read? Head note of the letter, Government of Arunachal Pradesh, Office of District Magistrate, Papumpare, District UPI. Order dated 16 May 2025. Order in compliance of the decision taken during the meeting held on 30 April 2025 under the chairmanship of Honorable Minister Home, Government of Arunachal Pradesh, regarding implementation of inner line permit system in state, all the weekly markets operating within the administrative jurisdiction of Papumpare District ruler shall be suspended until further notice. Accordingly, all the markets license issued to individual association or vendors for the conduct of weekly markets within the Papumpare District are hereby cancelled with immediate effect. So this is the very operative part of the order. So, your lordship,
So
This-
before cancellation of the trade license. No. Whether any notice was issued to you?
no any notice or no opportunity of hearing was given. that utterly violation of natural justice and violation of fundamental rights, so many fundamental rights, Your Lordship. That I will come in the later page.
This license was issued to you on 29/11/23
Yes.
by the Deputy Commissioner Papumpara
Yeah.
District.
For petitioner one, the license was
So,
issued on.
under which provision this license was issued?
The provision, it has not been mentioned in this order.
No, that's all right. But under what authority the District Commissioner, Deputy Commissioner Papumpara District has issued the trade license to you?
That is not reflected in the trading license, so I'm not unable to give that answer, Your Lordship. In trading license, it is not reflected.
Okay, no, the point for asking you is, he was authorized to issue trade license
Mhm.
by which act or rules?
Usually DC are empowered to issue trading license
Yes,
with for running the business within their
under
administrative jurisdiction.
which act or rules?
That Your Lordship, I'm unable to.
So, for cancellation of trading license, he has to follow some procedure.
Mhm.
There must be procedure prescribed in the said act or rules.
Yes, yes.
So, yes, madam,
Your Lordship, I will, may I please, Your Lordship? Your Lordship, I'm appearing for 124, Your Lordship. Your Lordship, I will read the annexure 1, annexed by the petitioner, Your Lordship.
annexer?
Annexure 1 of the petition, Your Lordship.
Yes,
Order.
that is the order.
Yes, Your Lordship, Your
Mm.
Lordship.
Mm.
The last line, Your Lordship, of the paragraph 1.
Mm.
All weekly markets operating within administrative jurisdiction of Papumpara District Rural shall be suspended until further notice. Your Lordship, that means it is a temporary order, Your Lordship.
Maybe.
Yes, Your Lordship. It may be resumed, Your Lordship. That is why, Your Lordship, what I submit that petitioners should have some patience, Your Lordship. They can wait, Your Lordship. Till the petitioners, Your Lordship. They can wait until the further order.
There is a
order, Your
violation of
Lordship. There is-
fundamental rights. So without any utterly violation of natural
Whether
justice.
any, before cancellation of the trade license, suspension of the trade license, or whether any notice was issued to him.
That I will have to take instruction, Your Lordship.
Because from order is.
First, we'll take it up at 2 o'clock. You obtain verbal instruction. Under which authority the Deputy Commissioner has issued this trade license? Page number 27 of the writ petition. And if under any act or rule it was issued, then whether any procedure is prescribed for suspension or cancellation of the same. And whether such procedure is followed by the Deputy Commissioner before issuing this annexure 1,
Yes,
2 p.m. today.
yes, Your Lordship.
But Your Lordship, let me finish my submission with just it will take 5 minutes, Your Lordship.
And that's all right.
Without looking into these parameters also, some more points I will like to
No,
submit.
that's all right. I understand your submissions. I have gone through the writ petition.
Because this order is based on compliance to the minute of meeting.
Yes, I have seen
Yes.
it.
And that is minute of meeting, which is not a law. This is not a notification. Minute of meeting can't be deemed as a
That's all
notice.
right. We will hear you at 2 p.m.
Much.
Okay.
Your Lordship may dismiss this writ petition, Your Lordship. Because for, yes. Because in the previous 4 occasions, he was absent, Your Lordship.
Well, this is a.
And moreover, Your Lordship, we are disputing the fact that there was no work order sanctioned, Your Lordship. There's a dispute, Your Lordship. So he has alternate remedy, not in the writ, Your Lordship.
My lord, in this regard, just I would like to press on. The bill was for the petition legs only. That is for the bill is for the special repairment and maintenance of the road and bridges, including restoration of the flood damage during the rainy season, which was happened. It is fact that the no work order is issued. but there is on the direction of the authority, the petitioner executed works. And after the executing works, geotech has been taken. That is in the page number 13.
Without any work order, how can you execute the work?
No, that was an urgency. It was directed by the authority concerned, executive engineer. Then we have educated, and they have accepted the educated works, and they due to that they have taken even geotech, and thereafter they have themselves executive engineer and executive engineer and superintendent engineer both has sought for the allocation of the fund as this was done in the urgency to the chief engineer. That is in page 11. And that is on the 27 2024. And it is accepted. They have accepted that I have educated, and they have already accepted that I have educated.
Where they have admitted?
Admitted in sense, the page number 11, page number 10 is page
No,
number
no,
10, my
they
lord.
have filed their affidavit in opposition, whether they have admitted in their affidavit that you have executed the work.
No, their objection is only, their contradiction is only that after trying for so many, because PAN has not, they said PAN is not sanctionable because work order is being not issued. But it is their authority that they have asked, otherwise they would not have sought for the fund to the chief engineer. And after seeking fund, they have enclosed all the geotech amount and palm, that is in palm is in page number 13. I'm in the serial number 1, page number 13. And all this has been done with the geotech. Everything has been done, and it is processed by the divisional accountant and executive accountant and superintendent engineer. And they have, from this, it is sufficient that they have accepted that I have executed the work. Although they have in their affidavit, they says that I have no work order, so I cannot. So that is not the case that they have failed to bring or they have failed to release me. It is an accepted point. In this regard, my lord, I would say only one simple line of the law. Law is very settled as per Contract Act, Indian Contract Act 1872, section number 79. It is very clear that after executing and when the work has been, the executed work has been enjoyed by the authority or the department, they are bound to compensate.
You are referring to?
Section 79, my lord.
39.
79. Particularly 70, section 70. Married, my lord, section 70. Obligation of person enjoying benefits of the non-graduate act, where person lawfully does anything for another person or delivers anything to him, not intending to do so graciously, or such other person enjoys the benefit thereof, the latter is bound to make compensation to the former in respect of or to restore the things so done or delivered. Officially, they have accepted geotech and they have sought for the fund by the authority, and now they are denying, after enjoying the benefits, they are denying that I have no work orders. This is against the principle, settled law of the Indian Contract Act 1872. Section 70 is very clear. And if they have not accepted my work, and if they have not processed for that bill, they have not geotaken, then I have nothing to claim because I have no orders to execute the work. It shows that they have it is evident sufficient to prove that they have directed me, and on the basis of their direction, I have executed. Although the paper of work order was not issued to me. And after the page number 10 is very clear that they have written to the Chief Engineer, Central Zone APWD Division, Itanagar, the recommendation for, it was 2 work was done by the different firm, 89 lakhs was sought. And certificate of LOC demand, page number 11. Abstract of LOC requirement, work details for the month of July 2020. And then works LOC demand, name, I am in the serial number 1. And the letter certified, that is in the page number 14, my lord. Page number 14. This certified the following project amount, source, funding, year, so and so, geotagging and project details entered into the MIC Arunachal Pradesh. They have even geotag that has been all the procedure has been completed. And only lingering on the basis of that, they have not issued a work order. In urgency, they have sought in urgency my help, and I have executed investing my hard-earned money amounting to bill amounting to rupees 47 lakhs. And now they are denying. And that is against the Indian Contract Act 1872, Section 70. Under circumstances, they cannot deny. If they have no response and no notice of the government authority, then that would be different case. So work order does not stand here. Yes, sir.
Can we ignore this certificate? Page number 14.
Page number 14, yes.
Your Lordship, we are disputing the very fact that there was no work order sanction.
Yes, of course, they are disputing. That is why I am approaching here.
In that case, Your Lordship, this read doesn't have to appreciate the facts and all when other party is disputing the fact itself, Your Lordship.
The fact is fact. This is official order. That is not created by me. This is done by the department themselves. It's not my documents. It is the authorities' documents who have ordered me. After, when I'm asked to labor for gardening, and later on, if they deny the payment of salary,
Your Lordship,
wages, that is not done.
Paragraph number 5 of our affidavit, Your Lordship.
No, that's all right. You say, whether it was issued by the superintending engineer.
Yes. It's not done by me.
Are you disputing this document?
Yes, Your Lordship.
We are
saying
if
that, Your
it is
Lordship,
disputed, the documents is disputed,
our
contradictory.
if Your Lordship may,
That is different issue.
Page number?
6, Your Lordship, an extra 1. May I, Your Lordship? Inviting reference to the letter mentioned above, which was received by the undersigned on 15 November so and so. It is to inform you that the undersigned is joined Palin subdivision on 6th October so and so is unaware of any work being awarded to MSTJ Enterprise and MSTT Enterprise as claimed by the claimant Sri so and so and so. No work as claimed by Sri so and so has been not found recorded under this establishment. On going through the list of pending bills and measurement books, there is no any measurement books record available in this establishment to substantiate their claim. The work order and first and final bill is also not available in this establishment till date of the name, Your Lordship.
Then what are these documents?
No,
Which is
may
so-
not be, because he's the assistant engineer, Palin subdivision.
Yes, Your
And
Lordship.
there's exhibit, no, this annex of at page number 14 is issued by superintending engineer.
Then, Your Lordship, I may be.
Executive engineer, superintendent engineer has issued. So the
Then I
denial
may be
is
allowed to
just
take
a
instructions
process
from the
of legal-
superintendent engineer himself.
Instruction.
Yes, Your Lordship. Because till that we have not received any.
The superintending engineer is a party here,
Yes,
party.
yes.
Yes, respondent number 3, Your Lordship.
That's one number 3. So who filed the affidavit? Respondent number 4. Executive Engineer Palin.
Yes, no, respondent number 4, yes, executive engineer.
So if this certificate at page number 14 is issued by the superintending engineer,
Yes, your lordship.
definitely that document will not be available in the office of the assistant engineer Palin.
Executive engineer, your lordship.
Hmm?
This affidavit has
No,
been
this
filed on
letter
behalf of,
is written by assistant engineer to executive engineer.
yes, your lordship.
So in his office, definitely those documents may not be available.
Then I may be allowed some time, your lordship, to seek the instructions from the superintendent engineer itself, also, whether it's-
My lord, everything is crystal clear on the record. So there's nothing, and this petition has been pending for so many months and year. They have taken so many times for
Heard
just
Mr. Nick
filing
Learned
affidavit.
Counsel for the petitioner, so I am learned government advocate for the respondents,
all the
authorities, for all the respondents. After hearing learned advocate for both the parties, it is provided that Mr. Reza, learned counsel for the learned government advocate for the respondent authorities shall obtain instruction in respect of Annexure A series at page number 10, 11, 12, 13, 14, and 15. And 16.
Yes, my lord.
And also in respect of Annexure B at page number 17. The said instruction shall be placed on record by way of an affidavit on after 1 week,
your lordship, after 2 weeks at least.
after 2 weeks. Okay, after 2 weeks.
Obliged, your lordship.
Obliged, my lord.
Lordship, on the last occasion, Lordship, I have allowed to take dusty service upon the respondent number
So
4.
where is the affidavit?
I have filed this morning, Your Lordship.
Today.
Yes, Your Lordship.
Okay, hard miss,
Tirimi.
learned counsel for the petitioner. And Mr. And long learned senior government advocate for the respondent authorities. The learned counsel for the petitioner submits that person to order dated 8/11/2024, she has effected service upon the respondent number 4 by Dastimut, and she has filed the affidavit today morning. But the same is not placed on record. Accordingly, it is provided that the shall is the matter on Wednesday, coming Wednesday, along with the affidavit filed by the learned counsel for the petitioner.
Bless you.
My lord, in this matter, my lord, we have already exchanged our affidavits. We have filed rejoinder also. And my lord, after filing of the affidavit by the government, my lord, the matter becomes, they have admitted, my lord. They have terminated my service on the ground that it was illegal appointment, my lord. After filing of the affidavit by the government, they admit that it was
You are in all the matters,
my lord. Yes,
all the matters.
yes. So, my lord, they admit that the appointment was done by the deputy committee district level, man. That they admit. But the only ground they have said is that it was approval was not taken from the competent of government, man, from the directorate. That's the only stand. And they admit that it's irregular. And similar situated cases has already been considered by the government, man, and they have regularized, man. That we have annexed the documents to show, man. In a similar matter, same kind of order, madam, that also, that person was terminated saying the same ground, madam.
But
Show me the order.
now Lordship may kindly see the order which was my appointment order page 35, my lord.
No, no.
Yes,
Show
yes.
me the order by
Yes,
this,
in my rejoinder, my
clearly
lord.
situated persons.
Rejoinder, my
authorized.
lord. May kindly take up rejoinder. Page it starts from 89, my lord. Annex 2.
Yes, 88 is the termination order.
Yes, my lord. And the termination of that particular person, my lord.
Yes.
Lordship will see the same order termination, method of termination, saying that it's illegal, my lord, appointment. Now Lordship will see page 89. Yes, page 89, annex 2, one. Whereas the following multitasking staff were terminated from service. Lordship got 89. Terminated from service by office number such and such dated 16/11/2023 on the ground of illegal appointment. Whereas after thorough verification of all records is found that the appointment of these MTS were made on the basis of departmental promotion committee conducted at district level. This may kindly be seen, district level. They were appointed at the district level. However, approval from competent authority was not taken, which is a procedural lapse. Now, therefore,
So
considering.
in their affidavit also, they have stated that it is procedural. lapse.
Yes, yes. In counter affidavit also, they admit it was procedural lapse. Malab, kindly see the affidavit also. Government's affidavit. Page 67, Lordship. Para 6.1.
Era?
Para 6.1, page 67.
Yes.
Yeah, that in exercise of power conferred under clause 4 of Article 16 read with Article 335 Constitution of India, Government of Arunachal have framed rules where white notification number such as dated 2/6/2011, whereby 80% of Group C and Lordship got Group
Yes.
C and multitasking staff erstwhile Group C post against direct recruitment quota reserved for APST candidates born under all the departments at district office included in district administration and district shall be filled up at district level. Because that has to be filled at the district level, only approval has to be taken from the government level. The recruitment of such posts are conducted at district level under the chairmanship of Deputy Commissioner of a concerned district. In an instant case, although approval is obtained from DC of Upper Subansiri District, Daporijo, however, then DDSC Daporijo had not obtained approval from head of the department before issuing appointment order of the petitioner. Therefore, all relevant records and file pertaining to appointment of petitioner are not available in the Office of Director of Elementary Education. Hence, in the absence of such record, the respondent authority has reasons to believe that no such appointment was issued from the Director of Elementary Education. Consequently, impugn termination number such and such dated 16/11/2000 was issued on 23/11/2020 against the petitioner. Hence, no illegality has been committed by the respondent by issuing the termination order dated such and such. Now, para 7, Lord. Next. That with regard to environment, when we make para 8, 9, and 10 of the petition, you are answering the respondent begs to state that the appointment on compassionate ground in the state of Arunachal Pradesh is governed by a scheme framed and issued by Government of Arunachal Pradesh, White Office Memorandum such and such dated 4/7/2001. The private objective of a scheme of compassionate appointments to grant appointment on compassionate ground to defendants, family members of government servant dying harness or who is retired on medical ground. As per a scheme, although petitioner may be eligible for appointment on compassionate ground, but her appointment is found to be irregular, having not been routed through head of the department as she was appointed by then DDC Upper Subansiri District at district level.
with approval of concerned deputy commissioner, which is found to be procedural lapse. Madam. They have admitted that one. It was only a procedural lapse. Madam, para 8 also, same. They admit as a procedural lapse. Your Lordship, that with regard to amendment made in para 11, 12, 13, 14, and 15 of the petition, your answering department begs to offer no comments. As same relates to matter of record. However, your answering department begs to reiterate that although petitioner was appointed on compassionate ground at district level, wide appointment order dated 2/8/2019. However, no any prior approval was obtained from head of the department by then DDC Upper Subansiri District Daporijo. Hence, evidently there were procedure lapses while making appointment to a petitioner on compassionate ground. As such, her appointment has been terminated by termination order dated such and such. They have admitted, madam. Lordship, in my rejoinder, your Lordship has also clearly seen, madam. Similar kind of order was passed in that also termination on the ground saying that illegal. But they admittedly there they considered that appointment was not illegal one. There was procedural lapse and government has reconsidered and restored all of them to service back. Similar, they cannot have a different yardstick for different employees. Therefore, my humble prayer is, same stand government should take in my case also, Your Lordship, pass a direction, I may be considered at par with the decision taken by the government themselves in such cases. In affidavit, they have admitted it's a procedural lapse, not illegal.
Yes, Mr. Tagum. And in other matters?
Same stand. Same stand.
Petitioners are different.
No, petitioners are different, The stand is same, because
So
lots.
all the
all of them-
petitioners,
Compassionate appointment.
Yes, compassionate. They admit, deputy commissioner has the powers to appoint, They are not denying that, because being the head of the district, and government has empowered the DC to make appointment. Only lapse is that approval was not later on taken from the government. Such cases, the government has considered, it's only procedural lapse, it can be corrected. After serving so many years, in the government, similar when the government has taken similar stand for other employees, and they have been restored. Their service has been restored. Why I should be not considered on the similar line?
Mr. Tagum, where it is provided that it has to be approval has to be obtained from the head office.
My lord, they are in affidavit, my lord. They are written petition, my lord. This appointment was done by the.
No, that's all right. But where it is provided that approval has to be obtained from the head office.
My lord.
That is from the Directorate of Elementary Education.
My lord, page 72 of affidavit, my lord. My lord, serial number 2 must talk about this in case of this selection, this to be done at district level, headed by the
Page number?
Page number 72 of affidavit of opposition, my lord. This is, my lord, how multi-staff MTS, my lord, is appointed.
Notification dated 2nd of June.
Yes, my lord.
Yes.
Now, my lord, this is now the recruitment part is done at district level, headed by the Deputy Commissioner Chairman, my lord. 3, my lord, selection board shall forward the list to the director, head of department, head office for issue of appointment order and maintenance of combined seniority. My lord, only that part, my lord.
So, can we, on the basis of this lapse, we can say that their appointment is illegal?
My lord, this is since it is admitted fact, my lord. It is a
procedural lapse is found to be irregular, appears to be irregular because in my respect,
Irregular, maybe irregular, but it cannot be termed as illegal.
my lord, rightly, my lord, right. In similar situation as it has
Then
been,
you regularize their service.
my lord, that can be, my lord. In that,
Like this page number 92, annex
90 years, my lord. That they have done, my lord. This one of this petition, my lord, Bharat Tang, my lord. They, in this, he was also appointed as a compassionate, my lord, same style, my lord. Later, they approached this honorable court, and during the pendency, but his case, other case was revoked, my lord, their termination, my lord.
So we are disposing of all these petitions,
My lord.
directing the respondent authorities to regularize their service, like this annexer 2, that page number 92.
Yes, ma'am. That will suffice, it will cover all, my lord. Yes.
My lord, that can be, my lord. Only because the similarly situated has been given benefit, it is difficult to this differentiate, my lord, this different yard state.
Right to equality.
My lord, that is why, my lord.
Heard Mr. P. Tagum, learned counsel for the petitioner, and Mr. Tagum, P. Tagum, learned standing counsel for the respondent in Education Department. And Madam Pango for respondent number 4. Here, no. In this petition under Article 226 of the Constitution of India, the petitioner namely Srimati Momi Seke Nalo has prayed for issuing direction to the respondent authorities praise for setting aside and causing the order number EED -12015 stroke 5 stroke 2023 dated 23rd 11/2023 issued by the Commissioner Education, Government of Arunachal Pradesh, whereby the service of the petitioner as multitasking staff has been terminated.
Yes.
And also to issue direction to the respondent authorities to reinstate the petitioner to the post of multitasking staff. Mr. Tafel, learned counsel for the petitioner, submits that the petitioner was appointed on compassionate ground in place of her father-in-law, namely Sri Tapak Nalo, who retired on medical ground, who took voluntary retirement on medical ground from the post of Chokidar stroke MTS in the office of the Deputy Director, School Education, Upper Subansiri, Daporizon. On 30th/11/2018. And she has completed her probation period on 30th/11/2020. Thereafter, on 10/10/2023, a so-called notice was served upon her. And the said notice was signed on 27/9/2023, asking her to show cause as to why her appointment made by producing forged and fabricated appointment order should not be cancelled. Thereafter, the petitioner has submitted her so cause notice on 12/11/2023. but the respondent authorities without holding any departmental proceeding in terms of the CCS within bracket CCA Rule 1965. Terminated her from the service along with 7 others by order dated 23rd/11/2023 in illegal and arbitrary manner. Mr. Tafo further submits that the termination order was issued without following any procedure and in violation of the CCS within bracket CCA Rule 1965 and also in contravention of the principle of natural justice. Referring to the affidavit in opposition filed by the respondent authorities, Mr. Tafo submits that the respondent authorities in clear terms admitted in their affidavit that there is only procedural lapse for not obtaining the approval of the approval from the office of the directorate stroke head of the department stroke head office for issue of appointment order. But Mr. Tafo has pointed out that the petitioner was selected by a committee in district level.
Yes.
District level, and the said selection was approved by the Deputy Commissioner Daporizo.
Yes.
Deputy Commissioner of Upper Subansiri District Daporizo. And further referring to Annexer 2 at page number 92 of the affidavit in reply, Mr. Tafo submits that the respondent authorities in case of similarly situated petitioners or candidates have regularized their service.
Page 89, not 92.
Here Annexer 2 is 92.
92. It's 90.
Oh,
Sorry.
Paging,
Paging difference, yes.
By order dated 17 December 2024, and the present petitioner is also similarly situated, and as a similar benefit may be given to the present petitioner also. Per contra, Mr. Dagum, learned counsel for the respondent authorities, referring to notification dated 2nd of June 2011, submits that the selection board shall forward the select list to the directorate stroke head of department stroke head office for issue of appointment order and maintenance of the combined seniority list of staff for further cadre management. But the same was not done in the case of the present petitioner, and as such, the respondent authorities in their affidavit in opposition have stated the same as procedural lapse. Procedural lapse. But Mr. Tagum has admitted that in case of similarly situated candidates, the respondent authorities have regularized the service. Regularized the service of some candidates by order dated 17 December 2024. And he has also no objection if similar benefit is granted to the present petitioner. But having heard the submission of learned counsel for both the parties, I have carefully gone through the petition and the documents placed on record, and also perused the relevant rule. Also perused the notification dated 2nd of June 2011 and the annexer 2 at page number 92 of the petition. In view of the clear admission made by the respondent authorities in their affidavit in opposition that there is only procedural lapse for not obtaining the approval from the head office, no, from the directorate, stroke head of department, stroke head office for issuance of appointment order and maintenance of combined seniority list of staff for further cadre management. In view of the notification dated 2nd of June 2011, the appointment of the petitioner cannot be termed as illegal. Cannot be termed as illegal. And further, from the annexure 2, it appears that in case of similarly situated candidates, the respondent authorities have revoked the termination order of some of the multitasking staff and reinstate them in their service. And since the present petitioner is also similarly situated, then she is also entitled to similar benefit. Thus taking note of the submission of learned counsel for both the parties, and also considering the facts and circumstances on the record, this court is inclined to allow this petition. The termination order of the petitioner dated dated 23rd 11 2023, number EED dash 12015 stroke 5 stroke 2023 stands set aside and quas, being the same failed to withstand the legal scrutiny.
In respect of petitioner, my lord, there's
In
other
respect of the
PRT.
present petitioner. In respect of the present petitioner. Further, by a mandamus of this court, the respondent authorities are directed to reinstate the petitioner in service and further directed to extend all the service benefit from the date of her termination, that is 23rd 11 2023. Is there any stay order operating?
No.
And consequently, all the benefits, such as all the benefits she is entitled to, which she is legally entitled to, shall be extended to her. The aforementioned exercise shall be carried out within a period of 4 weeks from the date of receipt of certified copy of this order. The petitioner shall obtain a certified copy of this order and place the same before the respondent authorities within a period of 1 week from today.
Yes.
Terms of this petition is disposal.
Much obliged.
Malad, others,
Same.
same, malad, the pages would be different, malad.
Okay,
She can.
we'll
Much
take care of it.
Yeah, please, your lordship.
Yes.
Lordship, as per the last order dated 07/03/25, the private respondent seeks time for filing a counter affidavit.
Respondent number
4, lordship. Private respondent number 4.
not file the affidavit
My lord, I'm on behalf of respondent number 4.
for
Yet I did not file because my client got car accident since 2 months back. So she's under the medical treatment. That's why I'm not able to contact her to for the fly filed.
so when you will be able to file?
Yes, Your Honor.
When? When
Your
you
Honor,
are
give me
going to
some,
file the
give
affidavit?
me some time to file it.
After
After 3 weeks.
3 weeks.
Yes, my lord.
Okay. Heard, Mr.
Yes, sir, lordship.
Learned counsel for the petitioner and Mr. Y. Ram, learned government advocate for the respondent number
123.
123 and madam,
Por.
your good name please.
Kyodayayo.
Learned counsel for the respondent number 4. The learned counsel for the respondent number 4 submits that the respondent number 4 is suffering from ailments and she needs some time to file her affidavit in opposition. And accordingly, it is paid that 3 weeks time may be granted to the respondent number 4 to file her affidavit in opposition. Where is accordingly allowed. Basis shall raise the matter after 3 weeks.
Right.
May I, Your Lordship? Lordship, I appear on behalf of petitioner side, Your Lordship. Lordship, I pray Your Lordship may give some two weeks.
2 weeks.
2 weeks for file respect in reply in affidavit in opposition. In respect of
You will file a reply
in
to
opposition.
the affidavit in opposition.
In respect of respondent number 2.
Respondent number
2.
2. Respondent number 2. Third, Mr. Your good
K
name.
Moses. K Moses, Your Lordship.
K.
K Moses. M Moses.
Moses, learned counsel for the petitioner, and Mr. Rirampo, respondent number 123.
Yes, sir.
123, and Mr. Jiru, learned counsel for respondent number 4. Respondent number 4. The learned counsel for the petitioner submits that he may be granted some time to file reply to the affidavit in opposition filed by the respondent number 123. Have you filed your affidavit?
Yes.
Against which affidavit?
Yes, Your Lordship.
For government.
Government, yes. Deputy Commissioner, Your Lordship.
For respondent number 123. 123. Where is accordingly allowed, races shall raise the matter after.
And Your Lordship, there is an interim order, it may be continued. Your Lordship.
Okay, after 3 weeks. After 3 weeks, interim order passed earlier shall continue.
Deeply obliged, Your Lordship.
Number 18.
Wait, please, Your Lordship. What steps were taken? Service awaited.
Step, when you have taken the step?
On the very next day of the order.
By registered post?
Yeah, registered.
Nowadays, you can track it in the website
Yes.
of the postal department.
Track consignment. Yes.
Track consignment.
Consignment.
You check it,
Yes.
inform this court on after a week.
After a week.
After a week. Heard, Mr.
Yes, tie.
S. Taye, learned counsel for the petitioner. Office note dated 29/5/2025 indicates that service in respect of the sole respondent is awaited. Is the matter after 1 week, awaiting service report upon the respondent. In the meantime, the learned counsel for the petitioner shall track the consignment in the website of the postal department and apprise the status before this court on next date. This after 1 week. Number 21.
Your Lordship, we have not received the instructions yet. Your Lordship.
Pardon?
We have not received the instructions yet. Your Lordship.
You did not receive instruction. Heard, Mr.
But Your Lordship, I have heard that the prisoner has been released already before filing of the district petition from his posting.
Lordship,
But I'm not confirmed with the Lordship, which is why a short date may be granted.
He has already been released.
Yes. Lordship, I'm appearing for the private respondent number 4. He was already, we have the copy, he was already released on 9th May 2025 from the station.
9th of May, before passing the order.
Yes, before passing.
May I submit also? Lordship, after the filing of this petition only, I have received the copy of releasing order. That too in the WhatsApp only, Lordship. After filing of the.
So this petition become infractions.
Yes, madam.
Lordship, only after filing of this case only I have received that too through the WhatsApp only, Lordship.
No, that's all right. Now, what
Proceed.
purpose will be served by pursuing this petition?
Lordship, my actually grievances is that, Lordship, this transfer order was passed at the behest of an minister, Lordship. That is the only ground.
No. Your official tenure is 2 years.
Yes, to
So you are there for 2 years, 8 months.
yes, Lordship.
Then
That's not
we are closing this petition.
Yes.
That's right. Heard Mr. D. Soikia, learned counsel for the petitioner, and Mr. Y. Ridam, learned counsel for the respondent number 1, 2, and 3, and Mr. Tafo for respondent number 4.
Yes.
During the course of hearing, Mr. P. Tafo, learned counsel for the respondent number 4, has produced an order before this court regarding release of the present petitioner from the post. From the district with effect from 9th of May 2025. Must before passing of the order dated 15/5/2025 by this court staying.
Status quo was.
Now directing to maintain status quo. Since the petitioner has already been released by the order dated 9 May 2025, before the status quo order being passed by this court on 15/5/2025, his petition become infructuous and accordingly the same stands closed. The release order produced before the court shall be part of the record.
Much of that.
Please, my lord.
My lord, this writ petition, I have challenged the discontinuation of my service by the respondent authority that to backdated. My lord, impugn order is at the page 26. This order was issued on the 1st of May 2021. Allegedly on the basis of order dated 22 October 2020. That is 6 months before order was allegedly passed. And by this order, my lord, may I read the order, my lord. In compliance of order number such and such dated 22 October 2020, temporary service of Srimati Yerokamda WC Mazdur is discontinued with effect from the time of issue of the discontinuation order. This division received the discontinuation order on 30th April 2021. Discontinuation order was allegedly received by the divisional office only on 30th April 2021, and thus could not comply with the order earlier. And due to late correspondence, Srimati Yerokamda had been paid monthly salaries up to March 2021. That is amounting to 1,35,585, which on the other hand is recoverable. And Srimati Yerokamda is hereby asked to refund the amount by any means as per her convenience. Up to, my lord, I have already served up to the 1st of the May. Now, even after obtaining my service also, they want to recover my salary also. And this order is, my lord,
She is of Group D or Group C post?
Group D, my lord.
Group D.
Yes, my lord.
So this Rafiq Mas's case,
My lord,
the decision of Supreme Court in Rafiq Mas's,
no, my lord.
you are not aware of that decision?
No, my lord. No,
So-
my lord, what they assign, this impugn order is of one region, and subsequently they give another reason for my terminations from the service. So no any so-called notice, Initially, they have said they are not satisfied with my daily routines work. As per the impugn order, impugn order is, my lord, next, second order is page 27, my lord. Here, my lord, in last second paragraph onward, my lord. And whereas the meantime, department is not satisfied with her routine work. And my lord, this order is issued by the superintendent of engineer coordination. Whereas, my lord, I am posted at Daporijo under the office of executive engineer. And my controlling officer has never issued any issue thereby complaining my performance in the duties, my lord, etc. And subsequently here, my lord, this superintendent engineer, he has assigned different reason why I have been terminated from service, in which is in page 32 annexure H, my lord.
Page 32.
32 onwards, my lord. Relevant paragraph, my lord, 33, page 33.
Yes.
Yes, last paragraph, last second paragraph onwards, my lord. Whereas on checking, it was found that Mrs. Yaro Kamda Mazdiru had submitted, number one, bogus certificate of class 8 pass certificate from Achinguri ME school. On inquiry, protested came from one of the panchayat leader from the area, stated that she had never studied in that school. Secondly, Mrs. Yaro Kamda did not attend training assigned to her, which is a mandatory training for department. On the basis of misleading breach of service and furnishing misleading document to the department and the absence of fundamental trust of a non-attending training were liable to be punished under the rule of law applicable to her, which led to termination of the service. In such a situation, she has no right to continuing her service in the department. Therefore, on the basis of 2 points, this department has hereby terminated you from the service under section CCS rule 1965 of rule 14, my lord, which is basically a major imposing major punishment. This has been served as a discontinuation order number such and such on 20th June 2020. The forgery of fake documents could be produced before the magistrate for further investigation. However, the department has kept it as a secret in order to maintain the tranquility and the peace for individual safety, except action taken by the department. The issue on the basis of a documentary evidence by which the articles of charge are proved and produced by or on behalf of disciplinary CCS rules 1965 of authority, my lord. But in the present case, my lord, there was no any so-called notice, no any disciplinary proceedings. Here, my lord, actually, brief fact of the case there, my lord. Actually, I was married to one of these private respondents' relative, say cousin brother, and my husband died in 2017. He was working as a WC, and after his death, I was engaged as a WC in 2018. Here is my lord. Appointment order is at page 21. Is of my husband, and he was appointed by this private respondent only, my lord. Page 21 is the, my lord, appointment order of my late husband, which was appointed engaged in 2013.
Hmm.
21.
21 is your appointment letter.
Yes, is my lord, is my appointment order of Sri Taro Kamda, which was issued by private respondent, who is the uncle. And then 21 is type copy, and then my lord, he died in 2017. And thereafter, my lord, I was engaged as a WC, which is at page 22, my lord. This is my appointment order.
Yes.
Yes. This is my appointment order, which is issued on 26 June 2018, my lord. What happened is that, my lord, after death of my husband, although I was having 4 children, and some problem arose in my matrimonial home with me and my in-laws and all. And because of that, my lord, there was a keva. And keva order is, my lord, page 23. In that keva, it was decided that they have, as per customary law, they have legally divorced me from my matrimonial home. And I was directed to return my bridal price and to hand over my children to my husband's family. And here, my lord, private respondent number 5 was the earlier superintendent engineer at the time of appointment and subsequently become chief engineer who has issued this order. He is the uncle of my late husband. And because of, my lord, these disputes and all, he just wanted me to, he just wanted to strip me off from this post. And without any proof, my lord, without any evidence, he issued this discontinuation order because in our family, there is a problem. And moreover, my lord, my superior officer, who is controlling officer, is the Daporijo, executive engineer. He has never made any complaint, my lord. And moreover, my friend was also asked to produce the record on the basis of which my discontinuation order was issued. But as per my friend's submission, there is no such order on the basis of which this my service termination order was issued. Because just to avenge, just to harass me, this private respondent number 5, now retired, he had issued this order, my lord. If there is any deficiency in my service, my lord, authority concerned can issue me a so-called notice, my lord. I can be asked to improve my performance, my lord. But no such thing was done, my lord. And he was allegedly issued in October of 2020, discontinued my service. But my controlling officer, even they were not aware of such order. They came to know only on the April 30th, my lord. So my humble submission is that, my lord, I just cannot be, my lord, removed from discontinued service, my lord, without assigning any reason.
Is there any stay order?
My lord.
Is there any stay order?
Yes, my lord.
Okay, now she is serving in the department.
Yes, at present she is serving there. And there is no any complaint from other except this private respondent number 5, who was our earlier chief engineer. And just because I walk out from our matrimonial home, he wanted to avenge this, my lord, problem, my lord. And if, my lord, I had produced.
Yes, Mr. Tarak. So without any departmental proceeding, how can you draw this inference that the article of charges are proved?
My lord, this is very, it is the difficult part. So
Pardon?
it is a difficult part for us, for me. So
No.
this case.
On the basis of the documents you submitted.
My lord, I'm submitting. The petitioner was appointed by the respondent number 5. Then.
So it is compassionate appointment.
Yes, she was terminated by the same person. Now, when this court called for the records, when I instructed the officer of this, now he is retired. Now, officer said that record of file or the record of that particular person could not be traced. So now everything is with respondent number 5. So there is some difficulties. So
respondent number 5 already retired.
Retired.
But the record is not available.
Not available. They have given.
You have not filed your affidavit or file.
They have given me this.
They filed affidavit earlier.
Even last opportunity was also given to me to terrace. That is very difficult. The entire record, I think, is with the rest number 5. So from the record itself also, my lord, honestly, there is some, since he got remarried to some other person, there was a local kebang. So there is some personal grudge against the petitioner by the rest number 5. It appears from the records.
No, forget about this kebang decision.
Yeah.
Whether from the other documents, you come to this order dated 26 July 2021, Annexure Ace.
Page 32.
So without drawing any departmental proceeding, without issuing so cause notice, how can you say that the article of charges are proved?
Yes, this is done by same person.
Same person.
Reservoir pipe.
So can it be said that this order withstand the legal scrutiny?
I don't do this.
So we are allowing this petition, setting aside
Yeah.
all the orders. Is there any direction to produce the record?
Yes, there was direction.
When?
On what basis termination impugnation order was passed? But we could not find out that report. They have given me this letter. I think.
All right. We are disposing of this petition.
No,
She is already in service.
Yes.
Any other matter? Two matter.
Let's get into the record, yeah.
हाँ ये चल रहा है वैसे। आज जा रहा है क्या? नहीं जाएगा। नेक्स्ट वीक भी है क्या? नेक्स्ट वीक भी है क्या? हाँ हो गया इतना बेचारा आदमी लोग है। बहुत ये केस है और एक चीफ इंजीनियर और मतलब और भी पसंद है मेरे को ऐसा करके दोनों जैसे अपना लाइफ का वो करना आदमी ऐसा करके इसके लिए जिसमें ऑफिस में आने में लेकिन सुमोड़ से करता है बाद में कंटेंट डाला है तो बेचारा भाई नहीं है जानता भी नहीं ठीक
Dove si trova videoconferenze o banana?
Item number 1. Met PG Lordship, my lord. Although yesterday your lordship directed the council for the respondent 1 to take the instructions in the matter, my lord.
May I please, my lord? Yes, my lord, as per instruction by the DHJ, my lord. DHJ represent only respondent number 1 and respondent number 2 has their own legal counsel, listening counsel, my lord. As per instruction given by the DHJ, my lord. So the DHJ has represent only respondent number 1. Other respondent, Union of India has not represent, my lord. In that case, no instruction has given there. Yes, my lord.
My lord.
Whether this petition is maintainable because there are no conflict between respondent number 1 and 2.
My lord, my lord, who is the standing counsel? We are not aware of anything. My lord, respondent number 2, 3, nobody is aware. Now, without knowing, my lord, how we can serve the copy, they appoint the advocates at their own. But we came to know that there is no standing counsel.
That's all right. Regarding maintainability of the petition, the dispute is between respondent number 3 and the petitioner.
My lord.
They are private parties.
My lord, respondent number 3 is the private party, my lord.
Yeah.
Who is the state undertaking, my lord?
Is there any conflict between the petitioner and the respondent number 1 and 2?
2 is the main concern, my lord, but the letter was issued by the 2, my lord, only.
So that's all right, but whether there is any indication in the contract agreement.
My lord.
So find the respondent number 2 on account of failing to make payment by the respondent number 3 and 4 to the
My lord, in fact, when the contract is awarded, my lord, which to respondent number 3, my lord, and the 3 is awarded subcontract to 2, then the transfer is only from 3 to 2. 3, 4 doesn't come into picture. Now, once the 3 is responsible for everything, then the payment which has to be made by the respondent number 2 to 3 is for the works to be executed. And accordingly, my lord, at page 599, my lord, the respondent number 2 has written that if the payment is not made, then whatever the guarantee is given by way of bank guarantee and the payment will not be made. Otherwise, you arrange for the making of the payment. That's why, my lord, I am at the present, I am praying for your lordship that your lordship may issue notice and may direct only that this amount may not be released. I'm not asking that the payment has to be made to me.
If tomorrow the respondent number 2 appears and he takes it plea that there is no conflict between him and the petitioner.
My lord, the contract. My lord, we are exercising, we are filing the petition for the in respondent number 2 because he promised by the letter number 599, which is a state and has given a direction. Now that direction must be implemented. Respondent number 2 has given a direction in page 599, and that direction must be implemented.
On the basis of the trade letter, any accident or any conflict between the petitioner and the respondent number 2.
Well, the question of contractual.
So directly the respondent number 2 exercising jurisdiction under 226.
Well, the sound is little, my lord. I think some is coming very slowly, my lord. The sound from your lordship, my lord, audible. My lord, what? My lord, I am not disputing.
Contract was between the respondent number 3.
My lord.
Respondent number 4 and the petitioner.
My lord.
So there is no contract between the petitioner and the respondent number 2.
My lord, in this case, there is no contractual dispute. There is no contractual dispute.
Yes.
Lordship may kindly see, my lord, the respondent number 2 awarded the contract to respondent number 3. Now the payment
Yes.
etc. are all to be made by the respondent number 2 to 3. Even in respect, of the subcontract of 4 by 5-4, the payment will be made by the respondent number 2 to 3 only. Now 3 will again make
Yes.
to the subsequent one. Now once and the transfer of property is only by respondent number 3 to 2. There is no 4 will not come into picture for the transfer of property in goods. Now my only prayer there was that the respondent number 2 has taken cognizance of the matter and had written and given a direction to the respondent number 2. Now once the state has given a direction to the respondent number 2, then it's a duty that it must be implemented. There's no contractual dispute. That letter cannot remain
No,
in
that's
the
all right, but the dispute is basically between the petitioner and the respondent number 4.
Lordship, may once
Both
again
are private parties.
My Lordship, may once again see page number 599, my lord. Private party dispute is a different thing, my lord. What the state has directed, page 559, so 559.
No, that's all right, but is there any contract between them?
No, contract will be between 2 and 3.
Yes.
And 3 and 4 contract will not be anything because the entire thing is between the 2 and 3. Even if they get the work done from anybody else also, then also it will transfer of property between 3 and 2. And I can place the judgment of the, my lord, I've given sent a copy also.
Yes.
The Punjab and Haryana High Court, my lord. That it is a contract between the contractor and the contractee only. Subcontractor will not come into picture.
Yes.
Now, when the contract was between the contractor and the contractee, that is 2 and 3, then whatever amount, because they are making payment of the entire amount to the contractor. Now the contractor cannot keep the amount and will not make payment to the person from whom the services were taken. That cannot be. That's why in the 559, my lord, it has been directed. Your lordship may kindly once again take the trouble, my lord, although your lordship has gone through 559.
No, I have gone, Mr. Saraf, I have gone through it, page number 559.
My lord.
I have gone through it.
Well, my prayer before your lordship is that, my lord.
This is on the basis of one representation filed by the petitioner.
Because
this letter was
my lord, because we filed a representation, because ultimately the payment is made by the respondent number 2. The entire payment is made by the respondent number 2 to 3, and thereafter the 3 makes payment to the subcontractor. Now, in case the subcontractor has not paid, it is the responsibility only of the respondent number 2. That's why the bank guarantee, everything was given by the respondent number 2 in respect of the entire contract. That's why the respondent number 2 has said that it must be cleared, otherwise the bank guarantee, etc., whatever deposit is there, that they will held up. Your lordship, once again kindly see, my lord. My lord, para 3, my lord. In this regard, the office directed your firm to pay the outstanding amount directly to so-and-so and submit NOC to this office within 15 days. If your firm failed to pay the cost of bitumen and did not obtain NOC from so-and-so, the outstanding payment then amounting to rupees so-and-so will be deducted from the incoming SPS so-and-so of the same directly to the supplier. Now, if the supplier, my lord, contracted 2 comes before your lordship, challenging this one that, they cannot issue such letter, I can understand. But what I approach before lordship, that this letter which was issued by the respondent number 2, that must be implemented by the respondent number 2. And thereby your lordship will issue notice. And because the petition should not become infructuous, I am not praying for anything. They have said that we will make payment. I am not asking your lordship, the director, to make payment. Keep this amount with them.
No. That's all right. You are not asking for payment. But the question is, is there any stipulation in the contract agreement
for
that the respondent number 2 will make payment to the third party against supply of material?
My lord, that you lordship may kindly see, because in the respect of the subcontract, my lord, the contract is only between 2 and 3.
Yes.
Now, where from he gets the work done, that is up to 2. But the payment is made by the 2 to 3 only in respect to the entire contract.
Yes.
And he is responsible for the same. You'll also see the judgment which I have sent Punjab Haryana High Court below. Copy below I've sent to the registry, I think below.
When?
Today below.
Any copy is it? No. No, the registry has not received any copy.
Below, I may by mail it was sent below.
Oh. Okay, you do one thing, you send again one copy.
Well, I will send one. I may read the paragraph below, short paragraph below at 577. I may just read below. Below, may I read below?
Paragraph number?
It is paragraph number 14 below, 14.
14, okay.
Of Punjab Haryana High Court.
Yes.
My lord. Where a subcontract, as you also got it below.
In your petition?
No, below, separately it was sent today below in the morning.
No, that document. Okay.
Because I knew that, Milo, this question will come up from your lordship, so in the advance, I tried to.
Yes.
My lord.
Yes, paragraph number 14.
14. Where a subcontract is given by a contractor, I'm sorry, Milo. This is judgment of the Punjab.
Yes.
Where a subcontract is given by a contractor executing a work contract, there is no privity of contract between the contractee and the subcontractor. Part of the contract may be given for the purpose of execution to the subcontractor, but that could not absolve the contractor of his liability to pay tax. Even the liability, entire amount of tax, that also the contractor will have to pay. A subcontractor is a part of the work contract and is not an independent contract by itself. Therefore, a subcontractor cannot be said to be liable to the contractee in as much as he is undertaking the execution the part is not from the contractor, but from the contractor. So and so. So the subcontractor's position, my lord, even in the tax also, even if he makes a sales, the liability of payment of tax is on the contractor. Of the response number 2.
Yes.
So, my lord, my prayer at this stage, my lord, because your lordship is, in case if there was a contractual dispute between 4 and me, then your lordship could have said. But this is not a contractual dispute between me and the respondent number 4. There is no contractual dispute. The dispute is about the payment which was to be made, and the payment is being made by respondent number 2 to 3, even in respect of work which I have executed. Even in respect of my work also, the respondent number 2 is giving the payment to respondent number 3 only. That's why the respondent number 2 has directed that in case you don't make the payment to the respondent petitioner, then from that amount it will be realized because he will get the payment and he's not going to make the payment. So at this stage, my lord, the balance of the convenience, that amount will remain with them, and once that it is there 15 days, he will arrange the payment and I will get the payment.
Okay, we will pass the order.
My lord.
Okay.
Because my purpose is that, my lord, because your lordship knows, my lord, that once the respondent number 2 already has directed, once the amount is directed to be, my lord, kept, then he will not make to the contractee, respondent number 3, and the payment will come, and on the next time after 3 weeks, the petition may become infructuous also, because the payment will be made.
Okay, we will pass the order.
My lord, this is my humble request to your lordship, my lord. Prayer.
Yes, okay. Next item.
I'm going to
Deeply
you.
obliged. Okay. Yes, madam, you receive instruction.
Your Lordship, very sorry to say, Your Lordship, I have tried to contact DC UPI, Your Lordship, since he is retiring today itself, Your Lordship, he is quite busy. He is busy in the formalities, Your Lordship. I'll take the
That's
instruction.
all right, then we are staying the order.
Yes, Your Lordship.
Oh, we are staying the order.
Your Lordship, but I could manage to procure one notification from the Trade and Commerce Officer.
Yes.
Is in the office only, DC office only, Your Lordship. She has provided me this copy, Your Lordship. Your Lordship, according to this, we can presume that, not presume, assume that DC has the authority to issue the trade license, Your Lordship.
That's all right. There is no doubt about issuance of this trade license and cancellation of the same. DC has the power. But whether he has followed the procedure,
that procedure,
whether he has issued notice before cancellation of the trade license or suspension of the trade license, that is the question.
We'll have to procure the provisions, Your Lordship.
Okay,
the consent
then let that
next week, Your
stay on
Lordship.
the order.
Your Lordship,
Yes.
Till then, Your Lordship, we may be provided one
No,
week,
no, no.
only next week, Your Lordship.
No.
We'll come with the instructions, Your Lordship.
No. You are suspending the trade license of some person without issuing notice, without following any procedure. And you have violated the principle of natural justice and also violated the right to livelihood.
Your Lordship, may I, if I allow, Your Lordship, if I am allowed, Your Lordship, may I read the annexure 2 of the page 22 of the petition, Your Lordship?
Section?
Annexure 2 of
Annexure
the page, yes, page 22 of the petition, Your Lordship. This is a minute of meeting, Your Lordship. A meeting was held on 30 April 2025 at 10:30 a.m. in the conference hall of Chief Secretary, AP, Civil Secretary, Itanagar, under chairmanship of Honorable Minister Home.
No, but that's all right. There is one resolution.
This is a region,
Minutes
Your
of the
Lordship.
meeting.
Yes.
On the basis of which it was done.
The order was passed, Your Lordship.
Yes.
But on the basis
before
of this
passing
meeting.
the order, whether you have observed the formalities, whether you have issued notice, you have given him an opportunity of being heard.
That is the main question, Your Lordship. That is why we'll take the instruction, Your Lordship. By next week.
Therefore, I ask you to obtain instruction.
I could not establish.
Let there be stay. Heard, mister? Pardon? N. Sara, learned counsel. Saha.
Your Lordship,
counsel
next
for
week,
the
Your Lordship.
petitioner, and Ms. P. Songita, learned counsel for the respondent authorities. In this petition under Article 226 of the Constitution of India, the petitioner has challenged the correctness or otherwise of the order dated 16/5/2025, number PP/JUD-08 of 2012, which will make it PT, passed by the Deputy Commissioner UPI. It is to be noted here that by the impugn order dated so and so, the learned Deputy Commissioner, the Deputy Commissioner UPI has Deputy Commissioner UPI has suspended all the weekly markets operating within the administrative jurisdiction of Papumpare district, which indicate rural, until further notice, and all permits issued to individual stroke association or vendors for the conduct of local weekly market within Papumpare district within indicate rural were thereby cancelled with immediate effect.
May I, Your Lordship, before passing the order, Your Lordship, Annexure 7 of the petition, Your Lordship, they have annexed the order passed by the DC ICC, Capital Complex, Your Lordship. But DC ICC has not been made party in this petition, Your Lordship. Without making him party, Your Lordship.
This just for reference. I am not accepting any reading from DC
But DCICC has also passed the order for suspension of the weekly markets, Your Lordship.
DCICR is not the part, not in the list. Because DCICR is for different, for reference, how this minor meeting has been misused by.
But
the
Your Lordship, I have been told that DC,
Actually, you know, very interestingly, why I have connected after DCICR, because minor meeting has been drafted on 7th, 2025. And DCICR passes the order before the drafting of minor meeting, which is on 30th. How, without any order from the higher authority, he has passed on his own the order.
no,
So,
the
can he
DCICC,
pass it in this ICR?
Yes.
So I just for difference for your lordship knowledge, I just.
but Your Lordship, DCICC has to be, made a party, Your Lordship, because his order has been annexed, Your Lordship.
I annexed it, but I'm not affected by the DCICR.
Then why the order has been annexed, Your Lordship?
Annexure doesn't mean that.
And also, Your Lordship, the license of the petitioner number 1 has been already, Your Lordship, already expired, Your Lordship. Your Lordship, the license of the petitioner number 1, trading license of the petitioner number 1 has already expired, Your Lordship, on 20th May.
Already?
Expired, Your Lordship.
Petitioner number 1.
Yes.
When?
Annexure, yes, yesterday, Your Lordship.
In the meeting.
Day before yesterday, I think.
Yesterday, day before.
28.
And this, hearing order has been passed on.
He has no locus standing in this case, Your Lordship. He has no locus standing because day before yesterday, his trading license has been expired. Your Lordship. That is why Your Lordship may kindly give us next week, Monday or Tuesday, we'll come with the instruction, Your Lordship. Monday or Tuesday. Because this order has been passed, the Annexure 1, the impugned order has been passed on 16 May, Your Lordship. Till now, they have waited. Only, this is matter of only 2 days, Your Lordship. On Monday, we will come with the full instruction, Your Lordship. Because I could not establish the day, Your Lordship.
There are 2 petitioners.
Yes, Your Lordship. Yes, 2 petitioners there, but petitioner number 1, locus standi is not.
Maybe he will take a necessary step for implementing the legal heads.
On Monday, Your Lordship, I'll come with the instruction, full instruction. Your Lordship.
And the method is not regarding the issuance of trading license, validity of business. Methods regarding impugned order is valid. The legality of impugned order, I am saying.
Your Lordship, that is why I'm begging for, I am praying that,
Okay, all right.
only 2 days, he can wait, Your Lordship, only 2 days.
Because it's affecting.
Because this order is of 16 May, 16 May, more than 20 days.
I am dictating the order. Please don't disturb me right now. Yes, কি করলো লাইন তো? It's to be noted. Mr. Saha, learned counsel for the petitioner submits that the Deputy Commissioner UPR has passed the impugned order dated 16th of May 2025. District Magistrate, not Deputy Commissioner, that the Deputy Commissioner Papumpare District UPI has passed the order on 16th of May 2025 on the strength of the minutes of the meeting held on 30th April 2025 under the chairmanship of Honorable Chief Minister, whom to review the implementation of the inner line permit system in the state, and further submits that he further submits that the impugned order was passed and by which and thereby the Deputy Commission District Magistrate has cancelled all permits stroke license issued to individual, association or vendors of the conduct of local weekly market within Papumpare district within bracket rural with immediate effect. And while doing so, the Deputy District Magistrate Papumpare district has not followed the procedure and he had not given any opportunity of being heard or to the petitioner and also not given any notice, and that with the cancellation of the trade license of the petitioner and suspension of the weekly market, it affects the right to livelihood of the petitioner and thereby violates the principle, violates the article 21 of the Constitution of India, and therefore he contended that the impugned order may be stayed till pending till disposal of this petition. Ms. P. Sangita, learned counsel for the respondent, learned government advocate for the respondent, appearing for the respondent authorities, submits that the petitioner number 1 suffered demise 2 days back.
Yes, Your Worship.
1 day, because yesterday I had yes, one day
On
back.
28 May, Your Worship.
And his legal heirs are not yet included in this petition, and also the petitioner has enclosed one order passed by the district magistrate, passed by the Deputy Commissioner, Capital Complex, Capital Itanagar, District Papumpare City, dated 30th April 2025, but said Deputy Commissioner, Capital Itanagar of District Papumpare City has not been arraigned as a party in this petition. And further, she submits that she may be granted some time to obtain instruction from the respondent authorities. Having heard the submission of learned counsel for both the parties, I have carefully gone to the petition and the documents placed on record. It appears that the impugned order dated 16th of May 2025 is based on the minutes of meeting held on 30th April 2025 under the chairmanship of the Home Minister to review the implementation of inner line permit within bracket ILP system in the state. And it also appears from the impugned order dated 16 May 2025 that before suspending all the weekly markets operating within the administrative jurisdiction of Papumpare district within bracket rural, and also cancellation of the permit, cancellation of all the permits or license issued to individual, association or vendor for the conduct of local weekly market within Papumpare district within rural. He has not given any notice and also any opportunity of being heard to the petitioners. It is submitted that by the aforementioned order, the right to livelihood of the petitioner have been have been violated. Right to livelihood as guaranteed by Article 21 of the Constitution of India is violated. Is violated. Para. The submission so advanced by learned advocates of both the parties needs further consideration. At this stage, issue notice to the respondents returnable in 2 weeks. However, no formal notice is required to be issued since Ms. Sangeeta entered appearance and received notice for all the respondents. However, extra requisite copy of the petition will be furnished to her during the course of the day. Pending further consideration, the impugned order dated so and so stands stayed till returnable date, and this stay is granted considering the fact that the same being passed without in total violation of the principle of natural justice, as no opportunity of being heard and no notice was given to the present petitioner. List after 2 weeks.
May I please, Your Lordship? Your Lordship, maybe, can it be after 1 week, Your Lordship?
Pardon?
After a week, Your Lordship?
After a week?
Yes,
All right,
after
after
next
a
week.
week. All right.
Or Your Lordship, next week?
Next week?
Yes.
Okay, all right. Next week. In the meantime, the petitioner shall take necessary step for
Extra
implementing
copy.
the legal heirs of the petitioner. Number 1.